Okay. Okay, can everyone see my screen? Okay. So, I'm going to take you all on to this subject of ABC workers' rights in Malaysia, protecting workers' rights and pursuing economic growth. Through this slide presentation, you'll be able to see the various legislation involving employment law in Malaysia, and the respective legislation, how it governs the relationship of employers and employees in Malaysia. This is the overview of my slides. I'm going to take you all a little bit of down memory lane, history of employment law pre-Merdeka. Then I'm going to take you all through contemporary employment law legislations, uh, contemporary issues affecting employment law, like the recent legislative reforms, as well as avenue to hear complaints when there are employment disputes. The history of labor law in Malaysia can be traced to colonial Malaya under British rule. The influx of foreign labor from China and India under the Sinke and Kangani system, respectively, were done to supply to the labor demands in tin mining industries and rubber plantations. As a result of the influx of workers coming in, workers, of course, will organize themselves to fight for better working conditions and also to safeguard their welfare. Unions are formed. And two most notable unions pre-Merdeka is, of course, the General Labour Union and the Pan-Malayan General Labour Union, which was formed by working class to deal with issues of working conditions among the working class. Of course, some of these what you call unions were actually infiltrated by Communist Party, and there's a need to regulate the labor sector and the relationship of trade unions under the law and how they functions. So these are a few legislations pertaining to employment law. The most common is the Employment Act, Industrial Relations Act, trade. The Employment Act is more on the contractual relationship between employer and employee. Many of you all who enter into workforce or going to enter into workforce will be see how this legislation takes place in governing the contractual relationship between your company and yourself. And some of you who will become self-employed business owners, this thing also applies to you, this act. Industrial Relations Act is more on the relationship between for industrial harmony purpose, trade unions and whatnot, recognition. But one thing that is most common in Industrial Relations Act is, of course, when an employee gets terminated, not happy with his determination, there's a avenue of complaint at the industrial court, which is created by the Industrial Relations Act to hear complaints from these employees saying that they are terminated without just cause or excuse. So all terminations must be given with reason. And if that reason is not proper, employers can challenge it in the industrial court. So next is, of course, the Trade Unions Act, which governs the formation of trade unions. EPF, the Employees Provident Fund, that is you'll see contributions being made by both employees and employers to this fund, and each year it pays quite a decent dividend. This is for the benefit of employees to help them to save money for their retirement. Okay. And of course, the Employee Social Security Act, that is so you may hear there's a form of social security or form of insurance for employees who are doing work if they face any accidents. If it's fall under the protected terms and condition of the SOCSO, they can claim for injuries, benefits, and coverage, those kind of things, you see. Next is the occupation, creating a safe workplace. Employees should be, there are many cases of industrial accidents. This is very important that working environment has to be safe. And if not, there are certain duties or certain responsibility that the the company has to bear if they fail to precedence. Next is, of course, the National Wages Consultative Council Act that governs the minimum wage in Malaysia, where this council is responsible to make recommendations for the implementation of minimum wage and the rates. Okay, I'll go to the Employment Act. So what is an employee is actually defined by Section 2 of the Employment Act 1955 and also the first schedule. So there needs to be a contract of service, meaning there's a employer and an employee. Employee takes home a certain salary, in exchange must render his services to the company. There's a degree of control that the employer exercise on the employee. So one of the most obvious indication whether a person is an employee or not is there's an employment contract, there's a payment of EPF and SOCSO. Whatever you usually see an employee gets, that person gets it. That's the most common way to see whether a person is an employee or not. So this Employment Act, they provides for the role of the Director General of Labour, which has a very wide powers under the Act to make investigation here complaints of employment law issues. Especially there's a mechanism to hear complaint and inquiries under Section 69 of the Employment Act 1955. So basic standards of employment are also laid down in the Employment Act, like the requirement of a written contract of service, a written contract, payment of wages, notice period, holidays, termination, maternity leave, termination and layoff benefits, and power of inspection and inquiry by the Labour Department or the Director General of Labour. And of course, the more recent law reforms that is pertaining to sexual harassment at workplaces, the notice of sexual harassment and all that things that the recent law reform. So contract of service equals to employment contract. So there are two types of contract: contract of service, employment contract, and contract for service. Contract for service are usually those independent contractors, and with the rise of gig workers, where gig workers are not necessarily employees per se, they are operating in a newer kind of area altogether because they work a little bit more freer, independent than the usual traditional workers. So when you all sign employment contracts, just be careful. You need to know whether you're signing an employment contract or an independent contractor's contract. Okay, I'm going to go to the next slide. So the usual things that you will see in the employment contract is like for what is the job scope, the task that you're supposed to do. It will be specified in your employment contract. The working hours as well. And if you work beyond that, you are entitled to overtime as per the contract or the Employment Act. So Employment Act sets down a basic standard apply to all employees. But if the contract of service or employment contract provides for better terms under the employment contract, the better terms apply. Okay, so other than those working hours, the probation period, the termination clauses, the notice period that both either party has to comply with before they can terminate the contract. Or if they give immediate termination, they are liable to compensate to the other party the state notice period required under the contract and also by law. So there are a lot of other provisions usually in the employment contract, such as annual leave, medical leave, emergency leave, maternity leave, and paternity leave. There are also clauses of confidentiality, intellectual property clauses as well. Confidentiality meaning certain things, that information that you handle as an employee cannot be disclosed to third party without consent of the company, because those are information that is privy only to the company and the respective parties privy to those information. There's also a tenure clause sometimes. Most contracts of employment are permanent in nature. But then there are those who are fixed term, where you are only engaged for 1 year or 2 years. Those are project basis. So if you are finished that term already and you're given a renewal of it, Sometimes many renewals of the contract, a fixed term contract, can be deemed and interpreted as a permanent contract. It's actually camouflaged as hiding as a fixed term. But these things also is important, which all of you should take note of if you sign an employment contract. It's usually permanent in nature, and if it's a fixed term, continuous renewal will also mean that you are a permanent employee, right? There are implied terms which are not usually written in the contract of employment, but it also applies, like the duty of fidelity, loyalty towards the company, duty of care and confidence, confidentiality. You should protect your employer's interests and also prevent conflict of interest. All these are very important because breaching it also means breaching the employment contract, which can be a misconduct and action can be taken against the employee. Okay, I'm going to go to the Industrial Relations Act. So this is the act which provides for employees not happy with being terminated for whatever reason that be. They can make a representation for termination without just cause or excuse at the Industrial Court under Section 20 of the Industrial Relations Act. It also provides for the appointment of the Director General of Industrial Relations, which role is to maintain industrial harmony and also execute all its roles under the Industrial Relations Act. This act also governs the participation of workmen in trade unions, trade union recognition process, collective bargaining, and collective agreement. So sometimes unions, when they form, they will enter into collective bargaining with their company. All right. So as the result of it is a collective agreement, meaning terms and conditions. Usually employees through their unions will fight for much better terms, and there's a collective agreement, negotiations between company and the union representatives to agree on better terms or a certain terms that's favorable to both sides. Collective agreement would govern the terms. For instance, your manufacturing company, your employers decide to go for recognition for their trade union. Union is formed, enter collective bargaining. The result of the collective agreement is terms and conditions which is favorable to employee. All that will be reflected in the employment contract, right? This act also provides for the establishment of the industrial court based on Section 21 of the Industrial Relations Act. All right, I'm going to go to the next slide. So if let's say you go to industrial court, you win, what do you get? Of course, the most primary remedy is reinstatement. You get your old job back. But sometimes relationship between employer and employee has soured due to whatever reasons for the termination. Hence, the court will say, okay, reinstatement is not suitable. We will give compensation in lieu of reinstatement. For each year of service, 1 month's salary. That is compensation in lieu of reinstatement. For then, another thing is back wages. For how many months they are not employed after the termination, they can claim those back wages. There's a cap of 12 months for probation employees, 24 months for confirmed staff. All right. Next is the memberships, appointment of Director General of Trade Union, and the constitution of trade union and pertaining to the funds and accounts of trade unions. EPF, very straightforward. Retirement plan for employees, or every employee has to contribute EPF, and their company will also contribute a certain portion. And at the end of the year, you get your dividend, which is declared. And also EPF is empowered. The board is empowered to make investment. That's where your dividend comes from. As a result of the investments that EPF made here and there, profit gathered, and this fund is supposed to be sustainable so that it can continue to provide for dividends for employees, and that is their retirement entitlement at the end. SOXO, Employees Insurance Fund, provides compensation for employees in certain cases where they are eligible to. Contributions are to be made by employees. Okay. Of course, there are also other benefits like EIS, which governs retrenchment benefits and whatnot. OSHA, this is to promote occupational safety, health, and welfare of persons at work. Is to establish the National Council for Occupational Safety and Health. It also empowers the Director General and lay down duties for employers or self-employed people pertaining to occupational safety and health of their employees. National Wages Consultative Council Act, this is on minimum wage. That's why you see over the years, minimum wage has been reviewed time and time again, and it keeps increasing because of the cost of living that's gone up. Minimum wage is just a minimum benchmark where everyone who's an employee has to be paid. Of course, does not represent living wage, which is higher, and that's the rate that a person should be earning if they want to survive or sustain life in certain areas or states. Of course, that's a different discussion for another day. All right. Then next we have the HRDF. This is for training of employees and upskilling. It provides for the establishment of the Human Resource Development Corporation, impose levy on human resource development for the purpose of training and development of employees, apprentices, and trainees. So there's a fund also being there's an investment panel to guide the investment of the fund. So contemporary issues. I think this time I'm going to pass back to Kyler. So here and before I continue to the next part, Kyler, over to you.
Okay, so thank you, Vince, for a very detailed insight into the employment related laws in Malaysia. So as we can see, there's a lot of different laws in Malaysia that actually govern the different part of employment. But today, since we have limited time, so we won't go into too details on all of this. Um, okay, next up, we'll are very delighted and very honored to have Rachel Tan here. Let me introduce her. Let me share my screen first. Okay. Sorry. Maybe share my screen a bit. Okay. Okay. Let me introduce Rachel first. So, Rachel is currently a industrial relation consultant, and she is one of the Malaysia's most sought after industrial relations consultants with over 20 years of experience in the field and a background in legal practice. She has conducted more than 1,500 or 1,500 hours of training sessions on employment law and workplace relations, equipping thousands of HR leaders and business owners with the tool to manage their workforce confidently and compliantly. Insights, straight talking style, and deep knowledge on Malaysian labor law. Rachel brings clarity, credibility, and a touch of charisma to every session she leads. A true IR heavyweight, Rachel doesn't just follow the laws, she shapes how it's understood and applied in Malaysian workplace. Today, Rachel will be mainly speaking on okay. She'll be mainly speaking on the CD, right? Okay. Constructive dismissal. So, without further delay, I'll pass the floor to Rachel.
Thank you, Kyla. And thank you, Vince, for the introduction on the Malaysian employment law. So, how's everybody? I hope you guys have lunch and dinner. While waiting, I was also kind of like snacking. So, because it's my dinner time. So I have a very short topic. It's a very focus on what wins. I'm just going to jump off from where he's talking about unfair dismissal under the IRA. So under the IRA, where you are seeking for reinstatement, there are two types of dismissal you'll find yourself in. Unfair dismissal, where you get terminated by your company, either because of conduct issue, performance issue, retrenchment, medical board out, yada, yada, yada. That's when they terminate you. Now, constructive dismissal, which Kyla cannot pronounce earlier, it's a situation where you decide to resign because you can't stand your boss. So these are the things that your bosses don't want you to know about constructive dismissal. Now, this is a situation that you're in, okay? It's a situation where you find yourself being either bullied, cold storage, or unnecessary burden by some new rules and explorative terms and condition or a unilateral change of terms and condition in your employment. So when you start working, you will realize that you have funny bosses. Bosses that are nice, bosses that are cool, and most of them, 99% of the percentile, hates you. So all bosses are the same. So what happened is you might be in a position where you are being caught not knowing how to feel, right? When you are being either targeted, right? So we know how being targeted feels. So everyone being bullied in your entire life, like myself, knows how it feels being bullied. But some of us are not very sure, especially if we are still very early in our stages of employment. We don't know whether it's just mere, um, ragging, or is it real attitude problem, or is this the real world? So the gray areas is where you all need to learn. I'm not asking you to use it as a defense mechanism, but at least you're kind of aware what is this all about, and if it ever happens to you, you know what to do. All right. So I'm going to talk about constructive dismissal, where you choose to resign because the situationship in the company is a no-go for you. All right. So how does it feel like? How does it look like? It's never a direct termination letter, but it's always a hint, I think you should leave. I think you're not suitable for here. I think you should not join this meeting because you are not required. Why don't you just hover around? No need to join this meeting. You don't have to be part of the WhatsApp group. You were never invited for lunch. It's a slow burn, being sidelined, being stripped of duties. You are supposed to be hired as an executive, but ended up doing a receptionist job. And then they tell you that it's okay lah, we're all friends, right? You just, or change your role without you accepting it because it's a unilateral change. And then you're telling that, this is just a restructuring, but it feels like you're being sabotaged. So you're not fired, but you definitely know that you don't want to stick here around for long. So that's the starting point of a constructive dismissal feeling. So I give you an example, but before I give the example, so there are principles to it. Now, give you the first and foremost, I'll give you an example how it feels. When they reassign you to a new job, stating that you're not performing, but they never did a poor performance review with you. They just tell you, I think you don't suitable for the job. Let me change your job. Right? Can it be done? Questionable, right? Because I don't know. He just told me I'm not good at it. But can they just unilaterally change my job? Or someone who constantly berates you, or giving you unrealistic deadlines, or threaten disciplinary action over minor mistakes, right? So, or they suddenly reassign you to a new role with different targets, despite not having any experience, or transfer you to an obscure location just because your contract of employment says you have a transfer clause where we can even transfer you to Timbuktu. So this is where you will find yourself, it feels like a CD. So, but the thing about CD is when you go to court, the burden of proof switches from company to employee because you are resigning. So you have to have the evidence to prove that whatever they are doing is constructive dismissal. So for you to do that, you must be the one carrying the burden of proof, discharging it in court before they have to prove otherwise. In the reverse, terminates you, they carry the burden and to prove to the court why they terminate you. So it's very different from civil court where the plaintiff the one who brings the case will have to prove the burden. In the industrial court, it's kind of the reverse. The one who terminates have to prove. The one who resigns also have to prove. So in the case of CD, unfortunately, the employee themselves will have to discharge the burden of proof first. So now that being said, what are the principles of CD? First, you must be sure that the company has breached a term, not a term, maybe a few terms of your contract of employment, whether it's from changing your job, demoting you, changing your salary, transferring you, although don't have a transfer clause. And that breach is something that is fundamental enough to justify you leaving the company. And as an employee, you must leave immediately. I forgot the word immediately, but understood lah. And if you stay on, right, to wait for the next bonus because you say, this company is horrible. I'll just wait up for the next bonus. For you to claim CD is pretty difficult because there's a gap of time. When you stay on, you sort of accepted the situation. That means it's not as bad as you think it is because you stay out. So when there's a breach, you must immediately leave. However, because time and again, people just leave immediately, in a later case, the court says that, guys, when it comes to work, right, you guys have to sort of pace yourself a little bit. Yes, when there's a breach, you can claim CD. But before that, why don't you give the company a chance to rectify? So there's a new rule in town where you must first inform the bosses that, hey, I think you guys are up to no good. I think you guys are doing not a lot along the lines of my contract, and I want you to rectify it. You must give them time for ratification. Failing which, then you can say, okay, I've given you time. You ignored my emails, you ignored my call, you pretend I didn't exist, and you're not planning to fix the problem. I will therefore decide that this is a CD, and I will be leaving effective today. No longer you just saw a breach and then you just walk away. Reason because they still want you to foster industrial harmony. Because sometimes you have to understand that when you work in an organization, right, they're multi-level. There are many, many layers of people. There are many, many layers of manager. The managers that's hurting you might not represent the entire company, right? So you should escalate the matter before you walk out of the company, right? Because the company would say that, hey, I didn't know this happening to you. If I knew, I would have looked out for you. I would have done something. Because the person who is doing to you is not the entire representation of the entire organization. That one you have to keep in mind. So it's always good to give time to express yourself, go up for grievance, then only decide to do the next step. Okay? So that is the fundamental. If you don't do it, then it's kind of premature, like you're left without even like filing grievance, right? So so some of the cases which I've quoted, and these are quite recent, 2025 case, 2024 case, right? They changed the role, they demote without a challenge change. So in the case of Jagdeep, they just changed the role without him having any experience. He cannot do it because he doesn't have experience in it. He's not even trained in it. I said, you will learn. If I know if I can learn, everybody can learn now, but I don't want the job now. That's not what I subscribe for, right? It's like I'm going to a law firm, ask for a lawyer job, and you gave me to become a tea lady. Of course, I don't want lah. I can learn to make good tea, but doesn't mean I want to do it, right? So another one, demotion without salary change. So Muhammad Naim made a mistake and he was demoted. They said that he was demoted because among other things like mistakes that he was doing, poor performance, but there's no change to his salary. So it's like, okay, wait, everybody makes mistakes. So why did you demote me? Right? But they said there's no salary change, so you wouldn't feel the pain. So the whole thing looks fishy, and he walked out on constructive dismissal. Show cause galore. This one is they repeatedly gave her up to 8 show cause letter. Now, for people who don't know what is show cause letter is a letter of explanation. When you make mistakes, the company will issue something called a show cause letter. It's not a punishment letter, it's just a letter formally to seek your clarification. Miss Wong was tagged, if I could say, by 8 consecutive show cause letter, right? And there's no outcome. Like they just ask her question, keep asking her question. So she's given suspension after suspension. Some are without a suspension. She was asked to explain, over explain, and again explain. Some of the letters were even named as extension of the earlier show cause letter. So all in all, it's just to make her feel terrible. All in all, is what to want her to leave the company. So eventually she left, but she claimed CD and she won the case. Cold storage, I think I don't have to explain. You guys know how it felt to be cold storage, being sidelined, etc. Transfer. Now, transfer, there are many types of transfer. In the case of Bank Muamalat, it is actually a transfer that, number one, is too far. It is not within his role as well. There was two elements actually. One is the transfer, one is they transfer him to a location and a role that is not what is in his contract. So there's a breach. Although there is a transfer clause, but the transfer wasn't bona fide. So that was why he walked away. He didn't go for he didn't take the transfer, he walked out. And that's what really happens in the real CD case. You just walked out. Another one from Petronas was outright harassment. In the case of sexual harassment, employee has also walked out. We have many cases in the past, but not the recent one. But in the past, there were employees who have walked out on sexual harassment and they filed against the company. Yes, not the harasser, because the company did not protect them when they raised a complaint against the harasser, and then they have no choice but to leave. So the lack of action by the company to protect your employee, to give them a safe environment, would then equate for their right to walk out. So that is on harassment. But in the case of Justin, is actually him being assaulted by his fellow colleagues, but he wasn't taking heed, right? So this is so far I have. I hope everybody understands. I hope I'm not going too fast. I don't even have much time, but I'll try. So now, what are not CD situation? If you find yourself in a genuine transfer, which is a federal court case recently, Tan Leong Huat versus RHB, this case has took the world by storm. So Tan Leong Huat also walked out on constructive dismissal because he didn't want to be transferred back to Malaysia, right? He was based in Thailand. He's the head of operation of RHB. He's been there for 15 years. He said it's unreasonable for me to come back. There is so many head of operation that you can hire in Malaysia. Why the hell you want me to come back to Malaysia? You can hire very well anybody in Malaysia. OCBC is also hiring a lot of people. Go, 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 go. But the company said, no, I want to bring you back because I have the very right to do so. The transfer clause that we send you to Thailand was the same transfer clause I'm using to bring you back to Malaysia so that you can impart your knowledge to the Malaysia branch. So Tan is not very happy, didn't turn up for work, and walked out on constructive dismissal and sued RHB Bank. This case was quite interesting because initially Tan was winning up to High Court. And by the time they hit the Court of Appeal, Tan lost the case because the court says, first of foremost, right, we have to look at the fundamental. Remember my earlier page where I talk about the principle of Bayer? There must be a breach. So the question is, was there a breach? Then everybody is like, oh, shit. Because all this while, they go on the pretext of unreasonableness, extreme unreasonableness. They just say that the whole transfer is unreasonable and therefore it's constructed itself. The court said, hang on, can we just back up a little bit? Can we just look at the principle? Did the company breach any term? And everybody's like, I guess not. So the court says, if the principle itself is not fulfilled, then why are we talking about unreasonableness? Yes, you can use it as a merit, but that's not the principle. So guys, before you say it's unreasonable, extremely unreasonable, right? And extreme unreasonableness can be justified. So the fact that he's been there in 15 years, the company completely understand. They gave him over a month. They paid him money for him to come back. They encourage him to do transfer of his children to international school if it's required. They will pay for the transfer operations, the ferries, the logistic and what's not. They were willing to do so, but he doesn't want to come back. So that the court said is not enough for you to reject the transfer because it's genuine. And the company was legitimately restructuring and wanting people to come back and help the Malaysia branch. So for you to reject something that is already in your contract doesn't make sense. So of course, Tan is not happy and he went to federal court. But before he can finish the case in federal court, he died of natural causes. Nobody did bad things to him, not RHB didn't do anything. I didn't want to say. But he died. And then when federal court make a decision, they were in agreement with the Court of Appeal. So genuine transfer, part of the contract, then it's very hard for you to say you want to reject the transfer. All right. And secondly, retraction of work from home policy. Now, he was given a verbal work from home policy as an agreement with the company, but he abused it, so they retracted. He got upset. He walked out on constructive dismissal. The court said it's a verbal agreement. It's a temporary measure, right? Removal of bonus and increment. Now, you have to understand that if you look at your contract in future, most of your bonus will say discretionary bonus. They will never say fixed term bonus. If it's fixed, they have to pay. 13-month bonus have to pay. Annual bonus is not. It's usually discretionary. Increment is discretionary. So that year, this particular person did not get her bonus and increment. Reason because she wasn't doing very well, right? And the company refused to give it to her, and she worked out on constructive dismissal because she's been getting it every year. Now, this is what you need to understand. In a company, when it's discretionary, you cannot say it's unfair because it's discretionary. And it's also depending on how you perform. But then again, because performance is so subjective, everybody thinks they are absolutely the best employee in town, not measuring against objective measures sometimes. We are all heroes in our own mind. So unfortunately, the court said, no, this is not constructive dismissal because it's discretionary and you didn't do well. Slight delay of payment. Now, when the company don't pay you money, they are breaching the contract. So, but the company was going through a difficulty at that point of time. They did tell the employee, just give us 1 more week, we will pay you the salary. But instead, some of these employees, including Mr. Ashok here, said that I'm only giving you 1 more day. If tomorrow you can't pay me, I'll walk because it's already exceed the 7th of the month, right? He left on the 9th officially, claiming constructive dismissal, but the court said, look, the company was genuinely informing you that they are unable to pay. As a matter of fact, the company paid him the day after he left. Managed to pay everybody the day after they left. So they wanted 1 week, they managed to pay within 3 days. The court says you could have just waited out a little bit more. The whole idea is to make sure we're all reasonable, right? So the court said just slight delay, but it's been informed of reasons why it's not really a CD. All right. So these are the things that you just need to take note of. Last but not least, the 3 R's of um, tackling CD. Raise red flag in writing. A lot of people don't like to do this, but speak up. Not only just speak up, put in writing. Any situation that you feel that the company is attempting to put you in, put it in writing, tell somebody, refer to your company's playbook, which I call handbook sometimes. You read your grievance process and see where you can help you, where it can bring you to the next level. You don't speak to your boss because he's unreasonable, fine, speak to the next available person. Is it HR? Is it legal? Is it integrity department? Someone somewhere is going to be an impartial party in an entire organization that will hear you out, right? And number 3, last but not least, give them time, give them one last chance to restitute, to remedial the breach before you walk out. So that to show that you have done all you can as an employee, you've given them time, they refuse to acknowledge the time that was given, and that's why you're calling it quits. Okay? So that is all for constructive dismissal. If you have any question, I will accept them, but I'll move the time back to Vince and Kyla uh, for whatever subsequent sessions that they have to say.
Okay, thank you, Rachel. I hope that we all at least have some idea on what CD is and what to do if we have CD in our workplace. So next up, I'll pass back the floor again to Vince to explain a bit on the current issues that are facing employees as well as employers. I'll pass the floor to Vince.
All right, thank you. Okay, I'm going to continue where I left off. Okay, thanks, Rich, for your constructive dismissal. As you all know, when matters go to industrial court, constructive dismissal is just one of those many issues that are brought before the industrial court. There are also issues of misconduct, theft, corruption, sexual harassment, all that are misconduct. There are also issues of poor performance of employees. These are the common reasons where people are terminated and then they're not satisfied. They bring the issues up to the industrial court, and it's usually for the employer, the company, to defend those cases, with the exception of CD, where the employee has to prove the case. Also, another factor is retrenchment. I'll take you all to it later, but for now, I'll deal with the contemporary issues. As you all know, Malaysia is part of the signatory to the International Labour Organization. Of course, for international treaties that we sign, we have to make amendments after those treaties are ratified, make amendments to our domestic legislations to bring the standards of the law in line with international standards. So that's why you can see recent legislative reform in the Employment Act, Industrial Relations Act, Trade Unions Act, and Occupation Safety and Health Act. The world is a corporate world, it's a capitalist society, capitalist world. So corporate governance and corporate trends will always have a way to affect or influence the operations of companies worldwide. And the emergence of environmental, social governance, ESG, and business and human rights does somehow affect employers' operations and also employees' rights. The rise in cost of living and also inflation is something that is worrying, especially in Malaysia, where we see workers salary does not go up year by year, but cost of living keep going up. Of course, employment opportunities, jobs are always affected by global economic issues. There's the recent trade war, tariffs, and also the geopolitical conflicts, and of course the emergence of artificial intelligence affecting uh, certain jobs, rendering some jobs obsolete due to automation and whatnot. So I'm going to take you to a little bit of legislative reforms. Why I bring up these legislative reforms, I know maybe not all of you here are law students or legally trained or whatsoever, but I'm trying to make it as layman as possible, because when you sign employment contracts, you will realize that sometimes those contracts are not tally with the latest update of the law. So what is that situation? Does that mean the contract applies or the law applies? The answer is the law applies. So for any term and condition which in the employment contract which is not tally with the law applies. Hence, the one that is governing the terms and conditions should be the basic standards in the Employment Act. As you all know, now the Employment Act covers all employees regardless of wage. Last time was like 2,000 below only, covering blue collar workers. Now it applies across the board. That is like equality. Why should there be discrimination between white collar workers and blue collar workers? Just because earn more doesn't mean that the certain protections the Employment Act. Back then there was a theory skills they are able to negotiate better terms and conditions of employment by themselves. But all that has been done away with the recent Employment Act amendments, where basic standards are laid down, applied across the board. So there's also a mandatory overtime pay now for those working below 4,000. All right, with the exception of those who are above 4,000, the company doesn't need to pay you overtime. All right, there's also a reduction of working hours per week. Last time was 48 hours maximum you can work per week. Now it's 45 hours. So if a company asks you to work more than 45 hours, what happens? Overtime pay comes in, unless you don't fall within the bracket of employees entitled to overtime pay. So employees can apply for flexible working hours, and if the employer doesn't agree, they have to give you a reason in writing. There's also the sexual harassment notice. All companies, they have to put a sexual harassment notice in a company to notify all employees that sexual harassment is not condoned in the company. There's also an increase in maternity leave from 68 days to 90 days. And also the introduction of a 7-day paternity leave. That's for husbands. Okay. Then there's also penal offenses against forced labor. For all details, you can read the Employment Act. I'm not going to go into it because it's not a law lecture. It's basically just to guide you all on what is employment law. Okay. So the Industrial Relations Act also has been amended. Back then, if you go to industrial court, you win or lose, not happy, you have to do a judicial review. Within 90 days, you have to file a judicial review application to the High Court. But now the law has changed. You appeal to the High Court within 14 days from the date of the award received. So there's also an automatic reference from the dismissal representation from Director General to Industrial Court. Last time, if let's say you're not happy with being terminated, you go to Industrial Relations Department, file your Section 20 representation. The department will bring it up to the minister first, and then the minister will refer it to the Industrial Court if there's a case or in his exercise of discretion. But with the new amendments, they have done away the role of minister. If let's say disputes cannot be settled at the conciliation stage, meaning when a representation is filed, there will be a conciliation meeting between both employee and employer, and will be facilitated by an officer of the Industrial Relations Department. And in the conciliation meeting, if let's say no settlement can be reached, automatically the matter will be referred to Industrial Court. Okay? Employers or workmen can now be represented by any person at conciliation meeting at IR department, except for advocate and solicitor. There's a reason why lawyers are not allowed to represent at the conciliation stage, because sometimes the role of lawyers may prevent a settlement from happening, because sometimes lawyers just like to incite conflict so that the matter goes to court so that they can make money. So there are certain reasons why lawyers are not permitted there, so that conciliation or settlement can be reached. But many cases, most of it won't be able to settle at conciliation stage, so you go to court. That's where advocates, solicitors, lawyers can actually apply to represent parties in the industrial court. Okay, the award of back wages and compensation can now be made to the next of kin in the case where a workman or employee dies during proceeding of a industrial court. And now with the the new amendments, employee of a statutory body may file representation at the Industrial Relations Department. However, before any representation can be filed, the minister will first have to consult the statutory authority concerned and by order published in the Gazette prescribe the name of the statutory authority. This one, I don't think it has been done yet. So no statutory body has I don't think anyone has attempted this route, but now with the amendments, it's possible, but subject to publication of in the Gazette. Amendments to Trade Unions Act. So now if you're in one industry, there can be multiple unions representing the employer. Because the removal of the previous restriction under Section 15.2 of the Trade Unions Act. There's also increased time frame for the application of registration of trade union from 1 month to 6 months. Limiting the grounds for refusal to allow registration. One is the Director General must be satisfied the trade union's object, rules, and constitution contradicts the Trade Unions Act and regulation. The name of the trade union to be registered is identical or similar to other trade unions or resemble other trade unions, and in the opinion of the Director General, likely to receive public or members of either trade union. In the opinion of the Director General, promote ill will and hostility between races, religion, and nationality. Okay, these are amendments to the OSHA. So now OSHA applies across the board as well to all places of work throughout Malaysia. Only industries specified in the newly amended first schedule are non-applicable. For instance, domestic employment, armed forces, work on board ships. Okay, the role of a principal. So for instance, a principal is a person who in the course of purpose of his trade, business, profession, or undertaking a contract with a contractor for the execution or under the contractor, whole or part or any work undertaken by a principal. Sometimes some businesses they are actually sole proprietor only. There's only one boss. It's not even a company. So the boss hires people. That boss also is what you call subject to OSHA. For instance, it may be a grocery store or kedai or whatever you call it. One person manning the whole business. That person is also under the duty to ensure a safe working environment for the employees hired by him. So there are also definitions for serious bodily injury defined by the fourth schedule of the Act, such as emasculation, permanent privation of either eye, permanent privation of either ear, privation of any member or joint, destruction or permanent impairing of the power of any member or joint, destruction or permanent impairing of power of any member or joint as specified in the fourth schedule. So under this OSHA amendments, there is a need to do a risk assessment. That means the employer has to do a risk assessment pertaining to the safety and health of the work at the workplace. Upon identifying the risks, the employer must take steps to eliminate or reduce the safety and health risks. So employees, this one may be applicable to you all if you all see a situation where, of course, it's dangerous. You under Section 26A of the new OSHA amendments allow employees to remove themselves from workplace in event of danger or the work if the employer fails to take steps to remove danger at work. So they actually a lot of emphasis on safety at workplace, because some occupations like factories which are or at sites are very dangerous. So that's why OSHA is a very important legislation to protect employees. So there's also increased penalties, increasing the amount of fine from 50,000 to 500,000 for failure to comply with the improvement notice or prohibition notice. These are the few things the new amendments take into account. So, okay, I spoke a little bit of corporate governance, introduction of soft approach of human rights advocacy through sustainability. For instance, ESG. Public listed companies are required to do ESG reporting. There needs to be there are also code of conducts for company directors and company secretary. ESG financing, companies can actually apply to banks for financing purpose to implement ESG policies. Carbon footprint calculation is also something that services and business now take into account for safer environmental considerations. So ESG is environment, social, and governance. So E is environment, social is actually employment law lah. G is governance. So anti-corruption, anti-money laundering, that falls within the G part. Business and human rights is more of a new thing. Malaysia, we are slowly getting there. There usually be a national baseline assessment of the country's standards of human rights and whether are we too far behind of the international standards. And if there's a gap, what do you do about it? A national action plan is done to guide the country to work towards reducing the gap between international standards and domestic standards. So that includes 3 pillars: protect, redress, and remedy. So protect is the state has a duty to protect human rights. Okay, the businesses have a duty to respect human rights. That's the second pillar, respect. Third is redress. If there is violation of human rights in the business or corporate world, there is judicial and non-judicial avenues where people can complain to get their voices heard and have their grievances addressed. So now employment lawyers are required to advise on SMEs and MNCs. SME is small, medium enterprise. There are also MSMEs, micro, small, medium enterprise, as well as MNC, multinational companies, on policies, including the drafting of such policies promoting BHR and ESG, data protection and privacy policy, sexual harassment policy, anti-corruption and anti-bribery policy, anti-money laundering policy, and others. So just now I touched about the global economic issues. I think all this you all can read on your own in international news. I won't take too much time on this. Other than that, global issues that have impact on the employment and business operations. When the global economy is not good, for instance, the COVID-19, we all saw how businesses are impacted. Retrenchment is the next thing that will happen. Companies will want to restructure their businesses to ensure that they are sustainable, but it has to be in line with certain principles of, for instance, the code of conduct of industrial harmony. Last in, first out, foreigners out first. Cut costs first before you retrench employees. Freeze allowance. All these best practices are laid down in the code of conduct for industrial harmony. So many people being retrenched, not happy, they'll file cases at industrial court to challenge the retrenchment for not being done in good faith. So misconduct, of course, when times are tough, the tough gets going, but some people don't see that. Some people want to do illegal things or do things that are wrong just for a quick profit, just because the economy is no good. They need to make ends meet. So that's why a lot of misconduct sometimes happen. Human greed, whatsoever. Those are cases that you see in the industrial court: theft, corruption, and whatnot. So last is performance. ICT has changed the way we work and will continue to evolve further. People are expected to increase their productivity skills to cater to the increased demand in products and services, and it's a more demanding world. So of course, issues of poor performance will always pop up in industrial court, where people have to check, companies have put people on performance improvement plan, still doesn't work out, companies have to terminate the employees, and employers not happy, they of course have a avenue to complain at the industrial court. So these are the few avenues to complain of, like where there are problems in pertaining to employment. Labor Court is Section 69. Employment Act empowers Labor Court to hear complaints pertaining to contractual disputes. For instance, unpaid wages and whatnot, unpaid leave, notice period, whatnot, goes to industrial Labor Court. Industrial court is for termination without just cause or excuse. Those are some of the case laws which I've quoted. Of course, the burden of proof, like Rachel highlighted, is always on the company to justify the termination was done with good cause or excuse. The standard required at the industrial court is one that is on balance of probability. All the company has to show is 51%, his case is more probable than the employer's case, then they win. 51% is the threshold. So it's also a court of good conscience and equity, meaning that the court are more lenient on admissibility of evidence in the industrial court as compared to civil courts. And pertaining to industrial relations jurisprudence, a lot of misconduct cases, retrenchment, poor performance, all that falls under the industrial court. That's where, short and simple, that's where the money is. If any employee wants to file a case against the industrial court, against the employer, they go to industrial court because they can get quite a decent sum of money. 1 month salary for each year of service. Back wages up to 24 months confirmed staff. 12 months for probation staff. Then the last the not so common option is the civil courts. The common law remedy of unlawful termination of contract and also contract acts apply. The remedies include compensation. Okay, these are a few of my sources, and thank you. This is my contact. If there are any questions or whatsoever, you can drop me a text or an email. I made to understand there are some questions being posted. Me and Rachel will try to attempt to answer those questions. And if there are any questions, I think this is a good time you all drop your questions into the chat box, and me and Rachel will do our best to address it accordingly. Thank you. I'm going to stop sharing my site shortly. So, Kyler, do I pass this to you so that you can moderate the Q&A?
Okay, sure. Once again, thank you, Vince, for your very detailed and very insightful sharing. I think although there's definitely quite a few issues that are facing employees and employers, but I do see a lot of positive reform as well in terms of all the employment laws. So I think we're moving in the right directions. So once again, thank you, Vince, and as well as Rachel, for the sharing. And now we're going into Q&A. So for now, we have 3 questions. We do encourage that if you have any questions, especially maybe with Vince's part, I think so, because for much of Vince's part, actually, he went through very briefly. So any specific part that you like to know more, I think you can post a question in the chat box. As well for maybe Rachel part, maybe you have a specific case that you like to know about. Okay, so without further ado, we'll go to our first Q&A sessions. Okay, so this question is for Rachel. So the question is, what are the early signs of red flags or unfair treatment, by the company? So
Wow.
now I pass it to Rachel to answer.
Thanks, Helen. And the first question will be, is Rachel and Vince related because they have the same surname? But no, we're not related, by the way. If that's it's good to mention as well. Well, red flags is very easy. Look at the environment, the turnover. If it's high, then you know something is wrong. People don't leave good places, right? People love to work at a place where it's stable, non-toxic. If you have a turnover that but there will be a day where you just walk in and then it's just an exodus of people. That happens too. It often happens when the employee has been there very long, or a group of them decided to live together and start something new together. So get your facts straight before you decide whether it's really a high turnover because it's a toxic environment or just because people are just starting new in life. So high turnover is one of it. Number 2, delay in payment of salary. That one is one of definitely is a sign of problematic companies unable to pay on time, overtime that is not compensated, all the red flags. And of course, depending on where you are, how you work, the demographics might be a problem. Like if it's too many of one race, then you realize you're not in the same race category and you're just a token race in the company. Where do you stand? Is that toxic? Is that red flag? Or will you suffer some injustice, racism? There's a possibility. So these are the things you just have to watch out as you learn, right? That's all I can say for now, lah. Each to its own, to be honest.
Okay. Is there anything to add?
Not on this question.
All right. If not, then we move on to the next question. So for this question, it is like this. How effective is the current law to protect the worker rights and what issues workers are facing currently? So I think this question is for Vince. Is it okay?
Yeah, I'll answer this. I think the current framework does provide for remedy for workers who are not happy with certain situations that they face to make complaints. I think Malaysia's legislation wise is quite okay. Is the enforcement part that can be improved, because you see actually a lot of complaints enforcement only happens when a lot of issues, the enforcement only happens when complaints are brought forward. So sometimes the enforcement authorities may not enforce the law or don't do enough auditing in the corporate world or in the companies. That's where a lot of people or companies think that they can actually get away with doing things that are not legal or below no one's going to complain about it. So with the decent framework, I think we can enforce on enforcement, and there needs to be cooperation between government and also the private sector, where private sectors, the the expectations of the government in terms of compliance of the law are put forward to the private sector, and private sector understands that and comply with it. Sometimes not because private sector doesn't just don't deliberately disobey the law. It's just that they don't know. They need to be guided, and that's why roles like rules that are played by us lawyers or even IR consultants, we help the private sector, the companies, to comply, to educate them, to guide them to be compliant of the law, so that minimize risk of enforcement towards them. And if really issues do happen, still complaints do being made, at least steps have been taken to improve the certain standards in the company, which enable the companies to resist any complaints or cases filed against them in court, and they can win those type of cases. So rules have, I think these are the few things that sometimes we as lawyers can do. Or of course, if the current framework can be improved, I think Malaysia is always, how do I put it, the world moves first, then Malaysia moves. So we always follow other countries' international standards and other countries that are more developed. So when certain standards or trends are being set by the market leaders, eventually will follow. So, but there's a 10-year gap, probably, or 5-year gap before Malaysia's catch up. That gives us an opportunity to educate ourselves as much as possible within that gap period, so that when it's time for us to enforce those standards and corporate trends, we are able to do so. And we as lawyers are able to guide the private sector, the companies, towards that direction. I think that would be my answer for that. Thank you.
Okay, thank. So moving on to the next question. Okay, so I think this question is for Rachel. So the question is it mandatory for employers to provide medical benefits for foreign expatriates or foreign expats?
Legally, we are supposed to pay for all examinations. So if we look at Section 60F, bracket 1 of Employment Act, the company, the employee, right, at the expense of the company, upon consultation may be allowed medical leave. So at the expense of the company means the company must pay for consultation. And under the Employment Act, everybody is covered. Whether you're local or expat, if you're being hired in Malaysia, you're covered and governed by the Malaysian law. The same benefits will be entitled to you as well. So all consultation is unlimited, but there is no law to say we have to provide for treatment, however. So there is a difference between paying for treatment and paying for consultation. The expense of the company, if you read Section F correctly, is only consultation. So all consultation must be forked and paid by the company. But treatment is questionable. Most companies have insurance that covers both. So if you are in the kind of company that provides both, you're lucky. So it actually gives you, it's a good company that provides for better benefits. That's how you do assessment of which company to join, right? So that's all for that section. It's a very simple question. Any other questions that we have from the floor? Oh, there's one. I have a question. From, okay. There is a question from Norjana.
Okay, we have another question. So I think maybe we'll go to Norjana question first. So I think the question basically asks if uh we saw someone workers getting abused, okay, and in this particular case it's probably uh, uh, foreign workers, okay.
To see a non-compliance, whether there's forced labor that happened in Malaysia. Forced labor, if you look at our new the few things that Vince mentioned, right? The penalty for forced labor is 100,000, right? So if they're mistreated, being forced to work, unfairly treated, harassed, this will fall under this category. If you make a report, they will come and do a compliance check, and if it fails, if they fail the compliance, the business owner will be fined, right? And there's a criminal charge. They can take criminal action against the criminal suit against the owner as well under the yeah. So you can make a call to the department and you notice something and they will work on it. Whether they really do, I do not know, but you can follow up with them and drop them an email. But of course, they require more information.
Anything to add on this, Vince?
Now my
So we move on to the next question from Imelda. So the first question is, are interns protected under employment laws in Malaysia? I think we'll answer this question first. Is it okay?
Sorry, Vince, yes, yes.
Yeah, I think the word that the Employment Act protects is the apprentice. Generally, whether the interns are protected, they fall under the apprenticeship contracts. But usually, some interns they only intern a month, so they may not fall under the protection of the Employment Act. I stand to be corrected. So that's the problem, and they are not paid minimum wage. So, but there is still general provisions of law that can protect a person if, let's say, there are criminal activities being done towards the individual. The penal code provisions apply where a police report can be made, action can be taken against certain individuals who break the law in the context of criminal law. Of course, there are also civil law which applies to protect an individual from another individual. So we are slowly heading towards the ideal situation where we want to consider interns as employees, but the relative consideration in the contemporary market scene or marketplace, or even what you call the corporate world, is there's a resistance to consider interns as employees, and doing away with their benefits because that will add additional cost to companies. But we are slowly moving towards that direction, and I think moving forward in a few years to come, or even 10 years to come, we will see interns legislative reforms happening to protect interns. And also, what are some of the common ways young workers can take advantage of and how can avoid? I'm not sure um, how to answer that question because I don't think it's clear enough. Maybe certain clarification can be made and we'll answer it accordingly. Jana, okay. Rachel, would you like to add on the interns part? Yeah.
Right. I do face a lot of these questions whether intern is protected under employment law the Malaysian employment law. Question, what kind of contracts are you giving? Are you giving contract of service or contract for service or no contract at all? So what's the difference of contract of service, which even just now Vince mentioned? Contract of service means employment contract, right? Contract for service is a consultancy or contractor service. That means you're here to provide a service, off you go. So often not, contract for service are like people like Grab drivers, right? Temporary promoter. When you go to, they come and do a weekend show, a weekend display. That is called a contractor. The legal term is called contractor. So interns, what kind of contracts are you given? You got to read and look what are the benefits are given. Are you given EPF? Are you given SOCSO? Are you being paid minimum wage? If that's so, then you are an employee of that nature. If you are not given anything, you're just saying that you're here to, by the way, learn, by the way, just enjoy yourself in the process of learning. Maybe you're not employed under the Employment Act, because all be covered by the employment law, because there is no real master servant relationship there, right? So there are a few companies that I know of have given employment contract to interns. And their interns do work more than like 1 month, 2 months, 3 months, even half a year. So depending what company you go to, depending on what they find the use of the intern, you might be granted different type of contracts, right? So that is what I perceive of interns, right? Different company do practice differently. Yeah. So the second question, some common ways of young workers being taken advantage of. I don't think the word is common ways of young people. I think the word young is unfair. I think I'm still very young, right? I get offended. People say I'm old, right? Taking advantage of is a very strong word. Yeah, I would think that you are only being taken advantage is because you didn't care much about yourself. If you're going to go out there, get a job, you must always remember, read the terms and conditions. Nobody, when you are out there as a 21 years old, fully graduate, you are a grown person. A grown person, whether you're 21 or 41, you are fully responsible for whatever decision you make outside. So including reading the terms of your contract. Taken advantage of is only because your lack of awareness. And this is the part where we are here doing it, giving free talks up to 10 o'clock at night, so that people get educated, paperwork, shout outs, free seminars, the things other people do to ensure the education. I can, I can, I can, I can teach you, but I cannot help you to understand the law. So you need to take the initiative and be responsible and be aware of your rights. So these are your personal action. So to say that you've been taken advantage of is possible, but we learn from it, we move away from it, we know what our remedies when that happen, and then we move forward. So that's how we deal with life. And it's going to happen every day for the rest of your life till you turn 60 and not ever work again. That's what I'm looking forward to, Vince.
Be your own boss. Yeah, I think that's the trend now actually, where everyone, if anyone's looking for career progression, to those who are more ambitious, working is just to gain experience, and eventually you set up your own business and be your own boss. Then you'll face different criticisms altogether, where we always complain about companies, but now you have to deal with those complaints altogether. But that's just a part of journey of life, right? Okay.
There will be a place in time where you are the worker, and there will be a place in time you become the boss. And then you have a different perspective in life, because the wind changes when you're standing in different grounds, different heights in life. So it's very normal. Next question is from Zafran. Does the employee, and oh, sorry, can I read that? Kylie, you would like to read that?
Yeah, sure.
Does the employee who is under the probation enjoy the same right as remedy as a confirmed employee, especially in terms of protection against unfair dismissal, access to legal? Yes and yes. The only difference is the amount you get is different, which Wins have just shown. If you're probationer, maximum you can get is 12 months back wages. But so far, Wins, correct me if I'm wrong, nobody in Malaysia ever gotten 12 months before. All right? Because you have never contributed so many years, so you cannot ask for, heaven and earth. You're there 3 months, and yes, you're unfairly treated, You cannot ask for 24 months back wages, 1 month for each year of service as though you're a permanent. Only permanent employee gets the benefit. For probationer, maximum you can go for is 12 months, but nobody ever gotten 12 months. If I can, how I know, because we've been waiting for somebody actually getting 12 months, right? So far, I think I've seen one with 10 months. That also, he was a probationer for more than a year. But he hasn't been confirmed. That's the truth. The position that he is in rendered him only that sort of remedy because of his position. But you will get the same access, the same standard Section 20 file, you get a lawyer, go for mediation, all the same. No difference. Right?
Yeah, I think one thing I want to add is that your probation is deemed extended until you receive your confirmation letter. So confirmation letters are important. So after you work for a few months already, after the probation period is over, follow up with your bosses to see whether you can get your confirmation letter. If not, your probation is deemed extended. So
Right.
that's that. Yeah. Are there any other questions? If not, we'll probably call it a day.
Zafran needs to have a subsequent question.
Oh,
Is it
okay.
fair to justify to keep extending? It depends. Of course, the employee can leave and then claim constructive dismissal, Zafran. If you think it's too long, it's unreasonable, then walk away. You don't have to stay. Because like I said, when it comes to, employment, right, it's both party must be happy in that situation. If you're not happy, you're happy to walk away. And you find that it's unfair, you have the right to file constructive dismissal. But extension of probation, unfortunately, is really up to the company, because if they think you're not performing, but they still want to give you a chance, they will extend their probation to it. But if you think that this is very funny, like it's already 4 times or 3 times, of course, walk away if it's unnecessarily too long. When I say long, right? How long is long? Maybe it depends, because I've seen probation period that's 6 months upon job, and then the extension is also 6 months. So they will say, yeah, it's only one extension only, not even like two extension. Is that long? So it's questionable also, because their company does have longer probation period, right? There's no standard probation period out there, right? Legally speaking, you don't even need to have a probation period if you don't want to. But if you do, you're bound by the contractual rules and regulations of your employment handbook and what's not. If it's 6 months, then extension is another 6 months. Is that long? Questionable. So yes.
All
Any more
right.
questions?
Yeah,
No
I think
more.
we can have one more question. Just one last question if there's any. If not, then we'll close this session. Is it okay? Maybe
Of
we
course.
give some time lah.
Yeah. I have no problem closing the session at 9:30.
Yeah,
I think you guys got exams soon, right? You say most of you have
yeah.
ongoing exams. Yeah, but if there isn't any questions, I just would like to end this by thanking New Gen and MCHR, and thank my co-speaker Vince as well for this interesting session. I never thought that after I left my job, immediately the first thing I do is to give a talk line. But truth be told, I am very happy to be here, and thank you for giving me the opportunity to do so. There are a lot of things to employment. General rule is don't go out there being defensive, because the whole idea of employment, or rather, there's no company out there is out there to kill their employees. One, we didn't hire you to terminate you, right? No ever company is out there to hire you just to terminate you. Everybody wants people, wants to work, wants long term, want loyalty, right? So don't go out there with a defensive mentality that everybody is out to eat you, right? Also, just if you are getting a job out there, try to be a little bit more savvier than your predecessor. So everybody probably heard this. I don't know, correct me if I'm wrong. People always say that recently a lot of companies couldn't find the right person for the job because they are all very um they're in the place where they're in the rut, and correct me if I'm wrong, but it's very hard to find the right person. Everybody now have a different opinion about what kind of employee they want, and then they don't meet eye to eye. So for example, the expectation of an employee, or at least the candidate, courteous, being courteous, being polite, and ask the right question. I was told that of late, a lot of employees kind of trigger the trauma of the interviewer quite a bit. Like asking questions like, "What can you do for me if I join your company?" Everybody get angry. It's like you haven't joined my company yet. But you see, years above you, ahead of you, have worked really hard for the company, and now you're asking him that question, which is kind of trauma triggering, right? It's unacceptable for them. So the right way to handle that kind of situation, for example, is to reword yourself in a more sophisticated way of asking question. For example, if you want to know what is there for you in the job, it's good to ask straightforward, but there's also something called use, reword in such a way where it's not trauma triggering. For example, you say things like this: May I know, if I can ask, what is the benefit attached to the position that I'm applying for? Same answer, same question being reworded, right? And that and the people were like, wow, this person is actually very sophisticated, asking sophisticated questions. Questions like, may I know what are the benefits? Also can, not an issue. But don't go around asking, if I join you, what do I get? So, it's okay to be straightforward, but there are ways to handle this sort of question. So be the sophisticated adult, ask the right question, prepare, and obviously, please go look up the company that you're interviewing. Even though that's not your preferred company, turn up, show up, show that you actually care about the resume that you put in. And also read up about the company. That's the only way you can get a job. And I can guarantee you, if you act the way I tell you to do, like sophisticated and all, you probably be your senior's boss in no time.
Okay. So, thank you for the advice given by Rachel. Is there anything that Vince want to add on?
I think I wish everyone who's going to go into the employment industry all the best. It's tough work out there, but with the right set of skills, people skills, a little bit of luck, a little bit of network, I think many of you can achieve it in life. And of course, there are always people out there who are able to help you. Reach out to those people who are kind enough to do so, and when you find those people in life, I'm sure you can. And I think wish you all the best, and hopefully as you move up the corporate ranks, we will have opportunity to collaborate with each other moving forward. So yeah, I think Zafir want to say anything or not? I see people turning on their camera, want to take a picture, I think.
Yeah.
Yeah. Okay, before taking picture, do Zafir has anything to add on? Anyway, Zafir is actually from MCCHR here.
Okay, nothing to add on, but yeah, thank you so much for all those who spend some time, despite exam and other commitments. Yeah, thank you so much. I pass back.
Yeah,
Okay.
nice.
Okay, so now before we close everything, I'd like to invite all the participants to open your camera as we take a group picture. Okay, we'll give you some time, maybe about 10 seconds. You may open your camera. And also, to add on a bit, after this, we'll send the slides right through email, is it? Zafir?
Yeah, yeah. I will
All
send
right. So, um,
and some
if you got
exam.
any questions, maybe since Vince contacts on the slides, maybe you can ask him. Is it okay?
Yeah, sure. Just
Yeah.
drop me an email or text. Right.
Okay. Is there anyone that's going to open your camera? If not, then we'll take the picture. Okay, so Zafra is opening. All right. Anyone else? Okay, if not, then we'll take the picture in 3, 2, 1. Okay. Let's have another take. Okay. Once again, 3, 2, 1. All right. Okay. Thank you once again to Vince and Rachel for today's very
Thank
insightful session. Thank you to Zafir as well as MCCHR for this opportunity as well as the support provided. And
you.
lastly, thank you to all participants for joining this session. Okay, I think that's it for today. Thank you all, and you may
Bye.
leave
Good
the
night.
meeting. Bye
Bye. Good night,
bye.
everyone. See you all. Bye.
Bye.